CV02339, State of Ohio, ex-rel Mark Cerreta versus the Starr County Board of Elections. We are here upon a petition for mandamus filed by the relator in this matter. At this time, this matter is set for a hearing based upon the expedited nature of this matter. At this time, the court would ask counsel to identify themselves and any clients or client representatives who may be present in the courtroom.
Thank you, Your Honor. And may it please the court, my name is Don Wiley and I'm representing Mark Cerreta.
Thank you, sir.
Good afternoon, Your Honor. Deborah Dawson, the Starr County Prosecutor's Office. Stephen Babbitt from the Starr County Prosecutor's Office, representing the respondents of the Starr County Board of Elections.
All right, very good. All right, upon review of this matter, the court has determined that it doesn't appear, and counsel correct me if I'm wrong, that there really is a question of fact to be determined. Pretty much the petitions are what they are, correct?
That's correct, Your Honor. And in fact, Ms. Dawson was kind enough to make a statement of the facts at the beginning of her brief that are the stipulated facts of the parties.
Okay.
So I don't believe it's going to be necessary to hear any testimony today.
All right. With that, then, the court has had the opportunity to review the petition as well as the answer and the brief that has been submitted. And I will allow the parties the opportunity to make oral arguments with respect to the law that's applicable in this matter. With Mr. Riley, it being your petition, you may proceed.
Thank you, Your Honor. May it please the court. We did file a brief today, and the clerk's office asked me to give you your copy.
Thank you.
I'm sure the court's well aware of the facts, and I'll be very brief in that regard. But Mr. Cerreta filed two petitions with regard to his seeking of a position for counsel at large in North Canton. His name and home address appear on the front of each petition. His name and home address appears on the back of one of the petitions, as he was also the circulator. But he did not, and it was simply oversight, attach his or include his address on the circulator statement on the second petition. So of the two petitions, he's got his name and his home address in three different places, but it's not in the circulator statement. For that reason, the Board of Elections rejected one of the petitions, which doesn't give him enough signatures in order to be on the ballot. And my understanding is we need to ask the court to make its decision before Saturday, because that's a deadline the Board of Elections is under to get his name on the ballot. And I've never been involved in a case like this, so I did do some research over the weekend, and there are two statutes I think the court needs to look at. The first is our revised code 3501.38E, and that statute sets forth exactly what is required of the circulator statement on a petition such as this. And as I point out, the statute just has two sentences. The first sentence, or that subsection of the statute, the first sentence says that on each petition paper, the circulator shall indicate the number of signatures contained on it and shall sign a statement made under penalty of election falsification that the circulator witnessed the affixing of every signature, that all signatures were to the best of the circulator's knowledge and belief qualified to sign, and that every signature is to the best of the circulator's knowledge and belief the signature of the person who signed it. There's nothing in there about the home address of the circulator. It's simply not in that statute. And the word address doesn't even appear in that statute. And as you note in the brief, we urge the court to follow the rule of not deleting words or inserting words into statutes when interpreting them. And in fact, the second sentence of the statute, I think, reinforces the fact that the circulator's address doesn't need to be on the petition, because that makes clear that if it's a statewide initiative, statewide candidate, or statewide referendum petition, that's when the circulator's home address is required to be on the petition. So our argument is simply, it wasn't done because we read the statute and thought, well, we don't have to put it in there. This was an oversight that it was there, that it wasn't there. But in reviewing the statute, I think it's very clear that the home address of the circulator is not required by the revised code. Now, Ms. Dawson brought to my attention 3513.261. And by the way, the statute that we had just addressed, that's strictly construed and it requires strict compliance. And I'm asking the court to strictly construe the statute and read it as it's written to come to the conclusion that his home address did not need to be on the circulator statement. Moving on to 3513.261, as I say, Ms. Dawson brought that to my attention, and that's a statute that says, here's what a petition needs to look like. And they actually reproduce the petition in the statute. But that statute begins by saying a nominating petition may consist of one or more separate petition papers, each of which shall be substantially in the form described in this section. And because it has that language of substantial compliance, the Supreme Court has ruled in Osborne versus Fairfield County Board of Elections, and that's 65 Ohio State 3rd 194 from 1992, the Supreme Court stated, and this is on page 196 and 197, RC 3513.261 requires only substantial compliance with the form of the statement of the candidacy. And there are all kinds of other cases that I've cited to the court that have this language of the form of the petition has to substantially comply with the following. And each one has said strict compliance is therefore not required. It's enough if the candidate substantially complies with the form. And there's case after case cited in the brief, and the one I'm going to ask the court to really look at carefully is Stern, where the Supreme Court has said that technical problems or absolute compliance with every technicality should not be required in order to constitute substantial compliance unless such complete and absolute conformance to each technical requirement of the printed form serves a public interest and public purpose. And the test in Stern is where the statute only requires substantial compliance, and the only omission admittedly misled no one, and there is no evidence of fraud or deception. The public policy favoring free and competitive elections outweighs the arguments for absolute compliance with technical requirements of petition forms. And in this case, if the court looks at the circulator statement, no elector or person who signed that petition could have possibly been misled about what Mark's home address was or was not, because the circulator statement can't be filled out and signed until after everyone has signed the petition form. And I think that if you apply that test to this case and you look at the facts of Stern and the facts of cases such as this, they're all minor omissions. It really had no effect on anyone who would have signed the petition. And when there's no question whatsoever that the petition is otherwise valid and fine. And I think it's somewhat ironic in this case that Mr. Cerreta was advised that his petition was rejected because the circulator statement did not contain his home address in a letter that the Board of Elections mailed to his home address. They knew what his home address was because it appears in 3 other places on the form. And so we're asking the court to order the Board of Elections to include Mr. Cerreta's valid petitions. There's no question of fraud or deception. There's no issue about are any of these signatures valid. He did sign the circulator statement under penalty of falsification laws, that he did witness every person sign the document and that it should otherwise be considered valid. And I know it's not binding on the court, but we did find one case in the entire country where this exact situation occurred out of Illinois, and it came down in every respect in favor of the candidate. Thank you.
Well, let me just ask you before you go,
Sure.
Attorney Warren, the standard of review, obviously, that this court needs to consider this case under is an abuse of discretion.
I think that's clear.
Okay. And where the Board of Elections obviously has a legal argument with respect to their decision to ostensibly defend it based upon that legal argument, how, in light of that abuse of discretion standard, how should this court rule?
in favor of Mr. Cerreta.
Well, I understand that, but in light of that abuse of discretion, how can the court say that they have legal argument and therefore there was an abuse of discretion?
Well, it's not just abuse of discretion. There's 4 standards that I think the court can apply. Fraud or corruption, which have nothing to do with this. Abuse of discretion is the 3rd. And the 4th is that they acted in clear disregard of applicable legal provisions. And I think if the court concludes that these legal arguments that I presented are correct, then the board has acted in contrary to these applicable legal provisions.
So not only that it was an abuse of discretion to deny the petition, but as it's also flies in the face of the law.
Right.
Okay.
And I think if you read the cases, like in Stern, I think there were 7 petitions filed. Some notary was required to notarize the signature of the candidate. And the notary stamped all 7, but only signed 6 of them. So there was no notary of that 7th petition. And the Supreme Court, that's where all this great language comes from, says, look, that's a technicality. Nobody really thinks this is an invalid petition. Just somebody forgot to put their signature as they were going through all these on one of the forms, so let the candidate run it. And I think you'll find that in all of these cases, the courts say, because this is such a technicality that we're talking about, it is an abuse of discretion. You should follow these laws, and there is the long line of precedent of encouraging free and competitive elections. And I think that weighs in Mr. Cerreta's favor as well, because as I understand it, with him included, there are only 4 candidates for the 3 positions open for Council at Large in North Canton, and there's a write-in candidate. So if this writ isn't granted, there won't be a competitive election unless you happen to know who the write-in candidate is. So I would ask the court to consider all those things, consider the cases cited in the brief and the facts in the Stern case, and urge the court to rule in Mark's favor in this regard.
Thank you, Mr. Miller.
Thank you.
Attorney Nelson?
Thank you. May it please the court, I hope that the court has had the opportunity to read our brief that we filed yesterday. If not,
I have.
oh, okay. I thought so. You've done your own research because you came up with the burden that they must meet, which is that, as you know, that he has a clear legal right to have his name placed on the ballot, and that the duty of the Board of Elections respondents has a clear legal duty to place it on the ballot. As Mr. Wiley just stated, there are 4 reasons why you could reverse the decision of the Board of Elections. The first 2 don't apply here, and it would be a clear abuse of discretion or a clear disregard of applicable law. In the brief, if you read it, Your Honor, and I'm not going to reread it to you, the respondents do not rely on 350138E completely. There are other statutes, as I cited in our brief, 3513.261, which does say at the beginning that this is the form of a candidate's petition, and you shall substantially take this form. Well, you can know from looking at it yourself that pursuant to the Secretary of State, the Stark County Board of Elections exactly chose that form. It does not further state that once that form is chosen, you get to pick and choose what parts of it you need to comply with. The first part, which Mr. Cerreta filled out, and we have to fill that out, is the candidacy part. Because I'm talking to a candidate, so you probably know that. At any rate, that part has to be filled out, and that is what must be completed. So, of course, you do not mislead the signers, which comes into Part 3. So all that information, which includes the address and that you are a qualified elector for the position you're running for, and it clearly does state more than statewide election. You list which ones you are running for. It is true that the circulator statement is at the end after everyone has signed it. The purpose of signing that is not that you are going to be misleading any of the signers. The purpose of that is for election of fraud, and that you are attesting that you are, since the law changed in June, that you are the person who witnessed these signatures, and that you are a resident of the state of Ohio, which is required by the other statute that we referenced in our answer in our brief. Prior to that amendment to that law in June, a circulator was also required to be a registered voter. But after the Nader v. Blackwell case, they amended that law. and took out the residency requirement, or not residency, but registered voter requirement. The cases I cited there showed you that under prior law, if you had the wrong address that was not registered with the Board of Elections, they invalidated that part of the petition. My clients, the respondents, believe that this is a strict compliance thing. This has never happened before, I'll tell you that, with Stark County where this has happened. We could find no case law either where there was an exception when the circulator was the candidate. So the respondent's position is that in order for us to ascertain that a circulator is attesting, and you'll notice on that statement, in that statute, we attached the pen of the statute to our brief, it says you must put in your permanent residence address. In reading the Blackwell case, which I can tell you I drudged through yesterday, it's a long case, and then a U.S. Supreme Court case that preceded it, states are given great leeway when it comes to policing their own elections, ways that they want to be able to prevent election fraud. A lot of talk in the dicta there to do with the Secretary of State's ability to subpoena folks, so we need to know where they live. And it's a technicality, it is, but it's not a burdensome technicality. It is put there for a purpose. And the public purpose is to make sure that we can have a way of ensuring there's no election fraud. Respondents would submit to this court that strict compliance with the requirement that the circulator's address be placed under his or her name is required, and that is why they would ask this court to deny the mandate's petition.
Well, let me ask you this, Attorney Johnson. And in looking at your brief, it appears as though an essential argument is that the reason that you need his address is to verify that he is an Ohio resident.
Yes, Your Honor.
Now, in this case, I guess somewhat that argument is undercut by the fact that, one, he is a candidate, and two, he submitted a complete petition along with, or completed as in, he has his address on it, I won't say completed as in total with respect to the signatures, but that he completed one correctly
Correct.
and one incorrectly.
Correct.
And couldn't it be argued that because one was completed correctly, the board could have determined that he was an Ohio resident, one, not only based on his candidacy, but because of the one that was filled out correctly?
That is the argument that the leader is making, yes, Your Honor.
Okay. Now, and let me just kind of follow up on that as well, because you did put some arguments with respect to the public purpose behind having the petition in a particular form and having this information. But what real public purpose is served by disqualifying disqualifying someone from seeking public office just based upon that mere technicality?
The respondents would answer, Your Honor, that they believe in strict requirements with all the requirements of the signatures, even if he had not signed it. If you argue that he signed the first one, but he didn't sign the second one, so because he lists himself as a candidate, what if he put his address in with not his name? The respondent's position, the Board of Elections' position is strict compliance.
So it's more than substantial compliance?
Yes, Your Honor.
Okay.
And they would submit that the substantial compliance language in the beginning of 3513.261 only applies to if you adopt this form. You have to adopt something substantial to this form. Well, they've adopted it. Once they adopt it, their position is you do not then get to pick and choose which parts of it you get to complete. You have to complete all of it. And you'll note there is one case that I did find that had to do with a juvenile judge. So it's not a statewide candidate. And one of many reasons that the court, I think it's the second district here in Ohio, down in Montgomery County, one of the reasons that they threw out some of his petitions was based on 3501.38, it was because the circulator did not put her address. So that case I put in there to sort of undercut the relator's argument that the 3501.38E only applies to statewide candidates, because that court, that was a 2010 case. Obviously, a juvenile court judge is not a statewide candidate, it was a county candidate.
Well, and I think that was the Wilcoxon
Yes.
versus
That's
Parchman.
right.
And I did have a chance to look at that prior to the hearing, and I think, as you correctly stated, there was more than just the fact
That's right.
that the address was missing, and it appears as though they couldn't even verify.
They lumped like 4 different reasons together and used that statute to support the reasons, which was the only one that did that.
Okay. Anything further?
Not for me.
Anything further, Attorney Wiley?
If it please the court, the Wilcoxon case, first of all, the circulator wasn't the candidate. There were 2 different people, and the petition was rejected because the circulator failed to list her address. The circulator's name could not be verified with the signature on file at the Board of Elections. The number of signatures on the petition was more than the number of signatures indicated in the circulator's statement, and the number of the signatures on the petition appeared to be fraudulent. I don't think that has anything to do with our case. There was talk about the purpose of 3501.38E1. That purpose, we've cited this in the brief, Your Honor, but the Supreme Court has held that the purpose of that subsection of the statute, and I'm quoting from Russ V. Lucas, is to protect against signatures being added after the circulator's statement is made. That purpose has been fulfilled here. Mark did sign the circulator's statement, and no signatures have been added. Finally, I would ask the court to consider the Osborne versus Fairfield County Board of Elections case from the Supreme Court, 65 Ohio State 3rd 194. It's a 1992 case. That case held that 3513.261, the form statute, requires only substantial compliance, not strict compliance. The Board of Elections is applying the wrong standard here. And if the court applies this standard and follows the precedent of being in favor of free and competitive elections and realizes that this is a technical defect, it was an oversight that was easily verified as to where Mr. Cerreta lives. And I even attached the exhibit, the letter the Board of Elections sent him, saying we rejected your petition. And the reason they rejected it is because he didn't fill out his home address on the circulator statement, and they sent it to his home address. I hope the court will take all of these matters in mind and grant the petition.
Okay. Well, the court will take this matter under advisement and will issue a written ruling by the end of business day tomorrow. Obviously, in light of the fact that you do have some time constraints and that Saturday the ballots have to be printed, is that correct?
My understanding is
They
that's
send them out.
absentee ballots.
The absentee ballots start on October 1st, Your Honor, but they do send them out to the printers on the 21st. That's Saturday, isn't it?
Yes. Okay.
That's what I was.
In light of that, the court will get a written ruling by the end of business day tomorrow.
Thank you.
Thank you very much.
Thank you.